righty, good afternoon. Thank you all for coming. If any of you are just coming in and you have not had your gold sheet by Dr. Gold to get credit, he's here, and you can turn it in right up front after we're done. So I'm going to make a few introductions and give you all an idea of what we're going to talk about today. None of us have any financial disclosures. So today we have two female pediatric ophthalmologists. Myself, I'm a pediatric ophthalmologist in Southern Virginia, and I am on the Omic board. And we also have Dr. Alyssa Rosenthal right here, and she's a pediatric ophthalmologist in Phoenix and is going to be presenting her case for us today. We also have two attorneys with us, Mr. Broning, who is on Alyssa's left, and he was her defense attorney. And we also have Paul Weber here to my right, and he is the vice president of risk management at Omic and also is an attorney. So again, welcome to you all. So what we're going to do today is a little bit different than some of our previous Omic talks. We're going to actually present a case from the very beginning, from when the patient first met Dr. Rosenthal to the very end of the trial. And we're going to take you through this case in a way that we not only discuss the legal aspects of the case, but also the professional aspects of the case and the personal issues that come with having a claim that can be so devastating to us as physicians. The goal really today is to allow you all to be able to make your case more defensible if you get a claim, which unfortunately most of us will, and also to minimize the stress that goes along with getting a claim. So as I alluded to, there's about an 8% chance per year that any of us in this room will get a claim, and most people don't go 35 years without a claim, only 5% of the lucky ones. At Omic, even though we as pediatric ophthalmologists only comprise 4% of the Omic insured physicians, we don't really necessarily get sued any less than anyone else. And what you can see on this diagram, that we're 4% of the insured, and we right now have 4% of the open claims, which is 12. Most of you have probably seen this slide because I show it almost every single time I talk, and it just reminds you of the very severe penalties and payments that happen with pediatric cases. These are Omic's most costly cases ever in its history, and you can see all of the pediatric ones outlined in red, and Paul Weber, who put this slide in, was kind enough to not highlight in red the corneal ulcer in the 2-year-old because it was a general ophthalmologist that was the treater, even though the case was a child. So, as you might imagine, the thing that we get sued for the most is surgery, and so this case that we're bringing to you that Dr. Rosenfeld is going to present is a strabismus surgery case. All right, so I just want to take a minute to tell you all that I read the trial report, every line in the trial report for the case that Dr. Rosenthal is going to present, and it made me extremely anxious. And it really must have taken a tremendous amount of courage for her to actually go through this trial in the first place. I really don't know if I could have done it. And equally as important, I think, is her bravery in coming here to stand up here in front of you all and go through it with you. So I know that everyone in this room will treat this with the utmost respect and professionalism during the presentation and also during the question and answer session. So with that, I'm going to let Dr. Rosenthal take it from here.
Good afternoon. So this was my life. It started back in November of 2009, and I had a nice 37-year-old gentleman come see me as a new patient in the office, unassuming, very nice gentleman. And his chief complaint was he had eyes wandering since he was a young child, and he wanted to do something about it. Healthy male, no significant medical or surgical history. His physical findings essentially were an amblyopic right eye, fairly large angle, intermittent, poorly controlled intermittent exotropia. Rest of the exam was normal. So we talked about his diagnosis, and the plan was a surgical plan of an R&R on his amblyopic right eye. At that visit, we discussed the surgical consent. There was a written consent that he signed. And also in my chart, I noted that we discussed the risk benefits alternatives, including loss of eye. And he understood these and wished to proceed with surgery. Of note on that visit, he was by himself. For the visit, he didn't bring anyone with him. That was in November. He came in for a pre-op examination so I could meet him one more time prior to surgery, and that was in January. And essentially there were no changes. We reviewed what the surgery was and what our plan was. He agreed, and again, he was by himself for that visit. Surgery was the following week, and it was an uneventful surgery. R&R on his right eye, general anesthesia, uneventful. During that time of surgery, in the pre-op area, again, he was by himself. And after surgery, I wasn't able to find any family member with him to tell how the case went in the post-op area. So at this point, it's just been him. The first phone call after surgery was the following Monday, so it went Thursday to Monday, and on that Monday, he called my office, and he spoke to my technician, and he had called complaining that he had a headache and wanted to know if he could take some ibuprofen. And my technician asked me, we said it was fine, and just in an abundance of caution, said, why don't you come in tomorrow to see me instead of waiting till Wednesday when your scheduled post-op was. This phone call was not documented anywhere in the chart. So I saw him the next day, and he had said, yes, he had been having headaches, but they were better after he took the ibuprofen. Again, he was by himself at this visit. He was using Tobradex ointment as directed, and his exam showed an improved alignment. His vision actually was better on this visit than it was on his pre-op exams. And he had some conjunctival hyperemia, some swelling, but overall, a fairly normal post-operative exam. One thing that, in retrospect, we looked at was that I did not specifically document in the chart that a slit lamp was used during that exam. But in my standard, what I do is a slit lamp exam. However, it wasn't documented. So the plan on that day was that he had status post R&R, everything was going as planned. He didn't particularly like the ointment, and he was still inflamed, so I changed him to some drops. And we scheduled a follow-up for 3 weeks after that. On that Friday, so approximately 3 days later, his wife called the office. And she called to say that he'd been taking ibuprofen daily for headaches, and that the pain from the headaches was becoming more severe. I had my technician specifically ask how the eye was doing, because I was most concerned about that, and she reported that the eye looked good and the redness was improving. At that point, we advised them that since his main complaint was a headache, that he should go to urgent care or his primary doctor, as long as the eye was okay. And this was documented, this note was documented in my chart. 2 days later, in the late afternoon, patient called in to talk to the on-call physician, who was not myself, but also a pediatric ophthalmologist. And he was complaining that he had a white head bursting on his right eye, and his eye was burning, and he preferred the ointment to the drops. So my partner asked him to go back on the ointment and to follow up with me the next day. There was a note created for this in our records, and then I did get a task in our system to say that he had spoken to the patient. Overnight that night, so Sunday into Monday morning, the patient's wife called and spoke to the on-call doctor again, and that he could not see out of his eye. The on-call physician said, follow up, you just show up at the office first thing in the morning. And the on-call physician also called me directly a few hours later and said, this patient's going to come back and see you. This note, this phone call was not documented in our records anywhere. So I did see him that morning, approximately 9 a.m. He brought himself to the appointment. He was alone. And he had said that he was taking ibuprofen for the headache. He noticed a white spot. It seemed to have popped, some burning, and then his vision went gray. I remember a lot of that is from my technician, but I remember specifically asking him if he had any pain in his eye, and he did deny that, and he said he was mostly just bothered by the change in his vision. So he was light perception in the eye. He had uveitis, posterior synechiae, hypopyon. There was no view posteriorly, and he had an endophthalmitis. Discussed that with him. We got him an immediate appointment with the retina specialist, gave him directions, told him what was going on, more treatment was going to be needed, and sent him on his way. Ultimately, he had a tap and inject initially, 2 vitrectomies, and he had an enucleation. So the timeline of all this is that I initially saw him in 2009. Surgery was January 2010, endophthalmitis the 1st of February. In May of that year, his wife called me at the office requesting that I admit liability for what happened, and I proceedingly told her to call Omic. And she did. And she filed a claim with them, and we'll talk about what happens with that, but ultimately Omic denied that claim a few months later. A few months after that, there was a request for records from plaintiff's lawyer, and approximately 10 months after that, I was served papers that I was being sued. And that was approximately 20 months after the event. And then the court proceedings were September of 2013, so almost 4 years this encompassed my time.
Thank you. Welcome, everybody. 4-year ordeal, and I'm going to be starting off with the first part of it, and that's the report to Omic by Dr. Rosenthal. I'm going to go over some general guidelines, and then I'm going to go over specifically what happened with Dr. Rosenthal's case. All the cases are different, so I want to give you an overview of how claims come into Omic, lawsuits are reported, what we'd like you to do if you have an indication you might be sued. First way you might get an indication is a medical records request. Oftentimes they're routine requests, and we don't suggest you call us on all of those. But if you get a request from an attorney, have you or your staff call us, fax, or scan and email the document to us so we can take a look at it, because we're never quite sure if you're explaining what this document to us over the phone is. It's sort of, well, just send it in to us. Let us take a look at it, and we can advise you. It doesn't take very long. Sometimes you may get a phone call or correspondence from an unhappy patient. That may be your first indication that there's something brewing. And it's a good idea to give Omic a call. You could call either the risk management department, you can call the claims department. We will decide who's best to handle that kind of situation. and decide if you go to the claims department, it'll open it up, it'll trigger your coverage. So there's a lot of good reasons for calling us at Omic to make sure that you have coverage for this claim in the future if it arises. Sometimes you may hear from a colleague, you may have referred the patient to a subspecialist be handling some complication or something that happened during a procedure, and the colleague may call you back and tell you that the plaintiff, or the patient in this case, is asking about whether you did something wrong, or whether the doctor, colleagues telling you, saying the patient is asking about the kind of care you gave, or an attorney for the patient has called the subsequent treater, and the colleague's informing you. So those are good times to call Omic. Claims handling. With Dr. Rosenthal's case, the patient contacted her personally over the phone, said, I want to talk to your malpractice insurance company. She knew what she was doing, going directly to the carrier. That is the patient's wife contacted. And that's an important point here. The wife is the one that's having most of the contact with the insurance company, not the patient himself. Dr. Rosenthal immediately contacted Omic. We put her in touch with the claims person who talked to her about the steps in the process, and the claims representative contacted the patient, and the patient sent a 3-page, single-space, typewritten letter demanding $1.5 million. And she went over her reasons and rationale why they deserved this money, and the issues that they felt justified the claim. Mostly they were saying pain, pain, pain. Throughout this process, my husband experienced this pain and was telling Dr. Rosenthal and her staff that is having this pain, and Dr. Rosenthal just wasn't paying attention to it, and now he's had this blind eye, and we deserve $1.5 million. So we explained the process to the patient's wife of, we need to collect records, we need to have the records review. This isn't something that we can do immediately. And we also explained the process to Dr. Rosenthal, letting her know, okay, this is the way this claims process plays out. We need to get the records. We're going to have them reviewed by a pediatric strabismus doctor internally here, and we will then communicate back to the patient and to Dr. Rosenthal our decision on this particular case. A lot of times what the claims department is doing when an insured calls them is sort of giving them an overview of what this process is like. And mainly we're telling them, don't panic. We've handled thousands of these. We've handled many strabismus cases. We've handled pediatric ophthalmology cases. Only 7%, I think it's not abnormal to kind of catastrophize and think of yourself in trial immediately. And we want to assure you that only 7% of cases go to trial. We win 90% of the time. Less than 1%, only about 20 lawsuits at Omic have we lost, and that's out of about 200 jury trials. So don't panic. And another thing when we're talking and doing intake with our insureds is talking about the medical record. We telling them don't alter, because I think when you get a case or a claim, you may not have seen the patient for a year or 2 years. You're wondering who they are. You go back, you pull the record, you see that you didn't chart something that you normally chart, and you think, well, maybe I'll just put that in there because I want to complete the record. So you don't feel like you're doing anything that's bad, but you think, oh, I'm just completing the record. So we tell you, whenever you're in litigation or there's a claim arising, do not alter that medical record. We say don't research literature. If you do research literature, do it with the guidance of your attorney, because it becomes work product, it's protected, and we don't want you to find something in the literature that can work against you if the claim is in process. Of course, if there's no claim, there's an untoward event or an unanticipated outcome, there's no claim. Of course, you're going to be researching the literature if there's something you need to know and find out about an insured. But we're talking about specifically when a claim arises. Don't discuss the medical legal issues with your colleague. Don't go to them and say, well, I did it this way, and you're sort of looking for affirmation that they would do it the same way. Talk about the issues perhaps on how you feel, but once the claim has arisen, again, Not before. It's fine to go and discuss, untoward or unanticipated events with your colleagues before a claim has arisen, but after it's arisen, it's not a good idea. The reason it's not a good idea is that when you're being deposed and the claim has arisen, the plaintiff's attorney will ask you, who did you talk to? You say you talked to so-and-so. Then that person, the plaintiff's attorney, has the right to bring in your colleague and ask them everything you talked about. So that's why you don't want to talk about it with your colleagues, the medical legal issues. So the claims handling, we're back to Dr. Rosenthal's specific case. We asked her to forward us a copy of the medical chart. We wanted a narrative of the care that she provided. We got the patient to sign authorization to release medical records, so we went to the retina doctor, got his records from there, from the hospital, and had an Omic physician review. So this was reviewed by one of our board members on the claims committee to give the claims department and the company an overview of these particular issues. So this is a request for a claims review. This is what goes out to our doctors on our board. We want to know, first of all, was the procedure indicated? And this is a really fundamental question on a lot of claims. I think Jim here can tell you that oftentimes the claim is, hey, the patient is saying, I was talked into the surgery. I didn't even need this surgery. I was fine. And then I went to the doctor, and then the doctor told me, yeah, you need this. And then, that's one of the issues. So was the procedure indicated? Does the record reflect a proper informed consent? We'll want our physician reviewer to tell us that. Any technical problems about the procedure? Was the post-op care appropriate? And this is where we're going to be talking about Dr. Rosenthal's case in detail. Did any act or omission deviate from the standard of care? Did it cause harm to the patient? Because there's duty, standard of care, causing harm, and then damages. So there's 4 elements. So we want to know, did this, whatever the doctor allegedly did or didn't do, did that cause some harm to the patient, some injury? And are there any other practitioners we want our physician reviewers to look, because there may be subsequent treaters that really cause the issue or the problem that the patient is having now, or a prior treating physician. And also we have post-operative care guidelines. This is something really was put in place for itinerant surgeons. A cataract doctor or refractive doctor has a big OD network, and they're going around and they're not really handling the post-operative care, and that's an exposure for us, the insured, and the company. So we ask our doctors who are reviewing these cases, are there any post-operative care guideline violations? So in this particular case, Dr. Rosenthal, we sent a letter back, and this is the substance of it. Please be advised, we completed our review of the case. It was reviewed by a board-certified ophthalmologist. There was no deviation from the standard of care by Dr. Rosenthal, and we deny your claim. So this was communicated back about September of 2010, and we didn't hear anything more from this particular patient or the patient's wife. And approximately a year after this, Dr. Rosenthal got the summons and complaint. The process server came to her office during working hours, and Dr. Rosenthal this was kind of like the sort of Damocles hanging over her head for about a year, knowing that this might happen, not knowing, because the plaintiff's attorneys don't tell you when they're going to do it, They have to do it before the statute of limitations. Dr. Rosenthal was very savvy about the statute of limitations in Arizona. She knew that it would run probably about, I think, January or February of 2012. So she's just sitting there waiting, and then one of her staff comes back and says, we have someone in the front wants to talk to you, and she knew at that point, without even seeing the person, who this was, and she said, well, send them back in the back, and she was served with summons and complaint. Dr. Rosenthal contacted us immediately. This is one of the things Dr. Rosenthal, throughout this, communicated very, very well with Omic. She never hesitated to call immediately when she first got that first contact from the patient's wife. When she was contacted, there was a medical records request. I didn't talk about that from the lawyer about 3 or 4 months after we denied the claim. She contacted us right away when this was served on her. So she was excellent insured in all those respects. So when this happens, when the lawsuit's served, boom, it's time to get the attorneys involved, because this is in their wheelhouse now. We're going to be working with them. We're going to be talking about that, but I'm going to be introducing now Jim Bronig, who is taking over the case at this point. Jim.
Sure, thank you. One more, all right.
There you go.
Well, thank you for having me here today. I'm confident that the reason that I'm here is because of my qualifications. That is, talking to captive audiences, juries, and physicians here, because they get a reduction in premium and CME credit. So anyway, we'll try to be as direct and as succinct we can. I've been asked to give you the overview of a lawsuit. Fortunately, most of you will probably never go through that. Some of you will. Some of you probably have. And I see in looking at the audience that we have a spread in terms of probably the years of practice. So I'm going to be very basic. I'm a lawyer. I could talk for hours. But I'll be very basic in terms of what happens once a lawsuit gets filed. Unfortunately, Dr. Rosenthal had to go through that process. But when the complaint is filed, that's what triggers, for the most part, our involvement. Sometimes we're involved before that. But in this case, and I want to make a couple of comments, we're a Phoenix, Arizona professional liability defense firm. All we do essentially is defend professionals, medical, other law firms, just about anything that you can be sued for as a professional. We have a number of lawyers that do nothing but medical malpractice defense. We have nurses on staff, and we work for a number of national insurers and also hospitals and large group practices. So I have a broad breadth view of insurance companies. You're very fortunate to be with Omic. Omic, as a specialized company, has so much internal knowledge about these types of cases that can really help you through the litigation process and simply the claim process. There are all kinds of assets on the website in terms of informed consents that might give you a head start on that. And so one of the advantages of being with a specialized carrier is that you have those types of things available to you that might not ordinarily be the case. And I'm not here to plug Omic, that's simply the situation. What happens when the complaint gets filed? Well, the complaint is really the outline of what the plaintiffs are claiming was done wrong. Basically, a complaint says, you did wrong, pay us lots of money. We file an answer to the complaint that says, we didn't do anything wrong, go away. And that sets kind of the framework for the lawsuit. Once that happens, the discovery process gets underway. The first thing we do is start gathering records. We get Dr. Rosenthal's chart, the charts of the subsequent treating physicians. We try to figure out what happened. Typically, we have a client meeting, and I'll talk about that in a moment, a little down the road. And I know that some of our physicians are a little nervous at times because this lawsuit thing progresses so slowly, but it's not a good use of your time for us to be meeting when the suit is first filed until we have had a chance to get through the records, get a feel for what occurred, and get into the case enough to have a conversation that minimizes your involvement. The takeaway for me today, for you, is that if you happen to be involved in litigation, let us take the stress off of you to the extent that we can. We take it seriously, as the defense lawyers do. Our job is to make this as painless, it won't be completely, but as worry-free as we can possibly make it. We invite your participation. I have physicians who never want to hear from me again, all the way to those that call me every week and want to know what's going on. Some who attend depositions are certainly entitled to do that as well. So whatever your comfort level is, we can work with that. We do periodic reports to the insurance carrier. Throughout the course of the litigation, you are always copied on those so that you know exactly what's occurred, the direction we're going, the plan, the issues, and how we intend to address them. We gather these records, and interestingly enough, we find lots of things in records that are very helpful. They may not be the practitioner's records. In this particular case, this man turned in a disability claim. And one of the issues in the case was what happened in terms of his complaints of pain versus headache. And in that disability form he filled out, he gave the history of what happened, and he used the word headache. That became important and a focal issue in the trial, and I'll tell you why in a minute. Theory of the case from the plaintiff's standpoint excuse me, was that there was nothing wrong with doing the surgery, there was nothing wrong in the surgical procedure itself, that it was the postoperative care that was deficient. Claim, as you heard from Dr. Rosenthal, was that a slit lamp wasn't used. It should have been. If only a slit lamp had been used, you would have seen the beginnings of this infectious process that developed into endophthalmitis and ultimately the enucleation. Also that because there were complaints of pain from the beginning, now understand that the records reflect headache, but in their depositions at the time of trial, the wife, who was really behind the lawsuit, swore up and down that they were complaining of this horrible eye pain or brow pain the entire time, which was wholly inconsistent with the records. So the claim was that because of this excruciating pain, Dr. Rosenthal at deposition acknowledged that in this type of surgery, typically she does it on a Thursday, and hopefully the patient, an adult, can be back at work the following week. Because that did not occur in this case, and because there were complaints of any kind of pain, that indeed should have alerted her to this process. In every litigated case, and I'm going to let you follow the time here, Paul, if you would. In every litigated case, it is the plaintiff's obligation to establish what the duty was, that there was a violation of that duty, how those violations caused damages, duty breach causation damages. You hear a lot of things about lawyers, and understandably so, when I turn on my TV here and see some guy on the thing saying, you know, we'll make the insurance company pay and we're going to fight them, or somebody's name on the back of a bus. But the obligation on the part of the plaintiffs is to establish this breach of the standard of care, the causation of the damages. And the important part is that you cannot process a case of this type unless some other qualified physician, some other pediatric ophthalmologist takes the witness stand and says, in my opinion, to a reasonable degree of medical certainty, the defendant violated the standard of care in these ways, and this is how it caused harm. So in each and every case, they have to have expert testimony. And indeed, there was expert testimony here on those issues. We, in the meeting with the physician, our goal is to establish trust, to explain the process, to invite participation, to make sure that our client understands that we work as a team. Please understand that even though, in this case, Omic pays us to defend the claim, it is Dr. Rosenthal who is the client, legally and ethically, so long as those interests are on track or parallel. That is the obligation to settle the case at a level that is acceptable, if that's what's going to happen, or try the case to whatever result occurs. As long as those interests are parallel, then everything's fine. But your defense lawyer hired by the insurance company represents you. And if there is a point where those two interests go this way, then we legally and ethically have to put the interests of the physician ahead of those of the insurance company. Sometimes, rarely, but sometimes, we have to make decisions, enter into arrangements that protect our client to the detriment of the insurance company. So you shouldn't think that this is the insurance company's lawyer, because that's not our obligation, and we shouldn't be reacting that way. Again, we work as a team. Now, How much involvement are you going to have as a practitioner in this? There are really only a couple of critical times. The first is the client meeting. What's the case about? What are the allegations being made? How are we going to defend against this? Help us understand the medicine of this particular procedure. I've been doing this for almost 40 years. I'm reasonably medically knowledgeable, but I'm certainly not even close to any of you in your areas. So Dr. Rosenthal was terrific in helping us work through all of this. So we need that advice. We need that input. We then talk about experts who we might retain to review the case. It depends upon what jurisdiction you're in. Arizona is a disclosure state. So the plaintiff's attorney is required early on to tell us the nature of the allegations and to submit an affidavit within 40 days of the filing of our answer saying what violations of standard of care there are and how those caused harm. Now, it can change as the discovery progresses, but now in some states, New York for one, and I am involved in cases all over the country, in some jurisdictions, there's no discovery at all. New York happens to be one. In some, Oregon is a state where there's some discovery of fact witnesses, but not necessarily of expert witnesses. So it depends. It's jurisdictionally dependent as to the scope of discovery and what occurs. Your involvement centers around critical times, the admission meeting, then your deposition. A deposition called into a conference room, court reporters there under oath, plaintiff's attorney asks questions. Our job is to prepare you for that process, to be there with you, to take you through it, to make you feel as comfortable as we can in terms of the types of questions that you're going to be asked and how to respond to them. A big factor in litigation is how to testify. There are lots of ways of telling the truth and lots of ways of answering a question. But our role is to tell you the best way to approach that process. Choosing experts. From the plaintiff's standpoint, as I said, they're required to have an expert. The expert will have typically either told us what the claims are or we will have sorted that out if it's a non-discovery state. Unfortunately, most of the experts that come in are well-intentioned, they're well-qualified, and they don't realize what they're doing in terms of the benefit of hindsight. There have been many studies run, both in the medical community and in the legal community, about hindsight and what information is given to a physician. There are a lot of them in the fields of radiology, for instance. Depending upon what history is known, what's picked up on an X-ray or a CT scan or MRI or whatever it might be. The same is true when you review a case. If you know the result, even though you may not realize that hindsight is being a factor or entering into your analysis of the case, it does. That's why when we retain experts, we ask them to do blind reviews. Our experts are given the file. They know it's a litigated case. They know something's being criticized, but we don't tell them what the outcome was or the allegations being made. Then I have the benefit at trial or in their deposition of saying, I didn't know what the outcome was. I felt the standard of care was met. And it makes a big difference. So that's what we like to do. But virtually every plaintiff's expert will have known and we ask them about this. And by the way, at the trial of this case, we talked very much with the plaintiff's expert about hindsight. As this discovery, the depositions of the fact witnesses are taken, the depositions of the experts are taken. In many jurisdictions, you're required to go through a mediation or settlement conference. We did that. I think Dr. Rosenthal will tell you that she didn't feel that she did anything wrong, and that was an uncomfortable kind of thing for her to have to go through. But the idea is that the physician has to be there to give consent or not give consent, but at least go through the process in good faith. So in most jurisdictions, some type of settlement conference will be held. We were talking a little bit about getting ready for this meeting and what our job is, and I can talk a little bit more about it at the trial part, but I have had so many physicians come to me and say, you know, I had a prior lawsuit, Jim, and I wish now that I hadn't settled that case, but my insurance company and my lawyer told me that that's what I should do, so I did. I don't do that, and your defense lawyer shouldn't really be doing that. What we should do is tell you what the risks are, our best judgment of the probable jury verdict value, the likelihood of defending the case, what the medical issues are, what the testimony is, give you all the information you need to make the best informed decision that you can possibly make. All I tell my docs, and I asked Dr. Rosenthal before this, and I think she remembers it, is, you know, I don't care whether you settle the case or try the case. If I'm not trying your case, I'll be trying somebody else's case. All I care about is that when you look back on this 6 months from now, a year from now, 5 years from now, you feel that you had all of the information you needed to make the best possible decision you could make. It's your case. And that's the advantage of having a professional liability policy because you have that consent clause, whereas if you're in an automobile accident, you don't. Your insurance company decides whether to settle or try. There are other things. How my time? I think I'm probably over. No. I'll chat with you just a little bit more about the trial in just a minute.
Okay, we're going chronologically here. And just to let you know that a lot of the information we're talking about and some of that we can't get to today is on the Omic the Aapos website for handouts. It's also on the Omic website, the Deposition Handbook for Ophthalmologists, Litigation Handbook for the Ophthalmologists, so if you need to refer to these at some point in time. So we're going to be talking about Omic's involvement in the case at this point. We were getting a very comprehensive defense case evaluations from the defense counsel in this case, about 3 or 4 of them over the course of about a year and a half, giving us an update on what's going on in the case, the depositions that are happening, the way the discovery is developing, the records that are working in our favor, the records that aren't working in our favor. We get reports again, like I say, about the depositions of the experts, of Dr. Rosenthal, of Dr. Rosenthal's technician, comprehensive overviews. And then it comes to the company's support or recommendation for going to trial. So it's incumbent upon us, Omic, the insurance company, because we've seen thousands of cases, to give Dr. Rosenthal the benefit of our experience in relation to that. And again, like Jim was saying, he gives a percentage of how many of these cases, what his percentage of prevailing at trial, and what his estimate is of the amount of a possible jury verdict. So we're also interacting most of the time through Jim in relation to counseling Dr. Rosenthal and what the company thinks. During the process, there's what's called an offer of judgment. This is the plaintiff's demand prior to trial, and in this case, as you heard earlier, the plaintiff's wife was demanding $1.5 million. They came down a little bit now, and to $1 million now. How generous of them to settle for just $1 million. And this was probably about a year or so before trial actually took place. Jim had a partner that was working on this case prior to him taking it over, and the partner's reaction to this offer to accept judgment was, "They are dreaming." And those 7 exclamation points are his, not mine. He really felt pretty strongly that that was an unreasonable demand that was not going to be met with anything other than no. But we do have to take these seriously, and we do have to communicate them and the attorney has to communicate them to Dr. Rosenthal. And, because at any point in time, Dr. Rosenthal, as was mentioned by Jim, she can consent to the case. She does have the right to withhold it or give it, and we have to give her those opportunities throughout the case. So I'm going to talk a little bit about, this is like generally what happens in a case. So I wanted to give you an overview. We have a claims committee, and they meet several times a year, and they go over cases with significant complex medical issues, significant financial risk. You could bet every ROP case gets discussed in that claims committee, where there's good experts and there's conflicting. Sometimes we get 2 or 3 experts on a particular case. We're retaining them, and we're getting different opinions from them. So those sorts of things have to get hashed out in our claims committee meeting, which has about 10 ophthalmologists there that are on our board and committees, and they're sitting around there. There's glaucoma, there's oculoplastic, there's general ophthalmologists, there's pediatric retina, there's neuro-ophthalmology in there. So you get all these people on a case, and it may be pediatric strabismus, but you get these different angles and different issues that come up, and it's important to have these different perspectives. And we Skype in the defense attorney, so the defense attorney will be there in Skype with that particular case, going over with the claims committee, so the doctor, rather the attorney, understands the medicine as well as you possibly can, and the claims committee understands the legal issues involved, because sometimes it's the legal issues and the evidentiary issues and the witness testimony that drives the case, not the medicine. So we have these claims committee reviews, and we decide when a settlement might be appropriate and for how much, and then we recommend that to the insured. If generally the insured's consent, if we're coming up with an amount, oftentimes the insured has already consented to settle the case, and we're deciding, with the attorney how this might be done. Sometimes they haven't, and so we're just doing it in advance. So if they do consent to settle, then the company has an idea of what the amount might be that we would suggest to settle the case. And then it's up to the attorney to negotiate that. Again, sometimes at these mediations with the insured. So we were thinking about this particular case, to know when to hold them, know when to fold them, what's it worth, and what are our chances. So in this particular case, this is a request for settlement/trial authority. So it's a little blanked out up there at the top. And it talks about Dr. Rosenthal's case, the synopsis of the case, the current status, where it is. It has a claims coding sheet. It gives you the verdict range from about $250,000 to $350,000, the settlement range. And down here, you can see insured's consent, and here, insured wishes to defend. You could probably put an exclamation point on that one with Dr. Rosenthal. She was unwavering from beginning to end on not consenting to this case. Counsel recommendation, Jim saying defend at trial. This is our internal Omic review, standard of care. This is the staff recommendation, request trial authority, and then you have the checkoff box. This is by our claims committee chair. Take this case to trial. So this didn't go through a full claims committee review. This was something that was pretty well understood by everybody. It had been reviewed internally by 2 pediatric ophthalmologists. The reports that we were getting were all very positive in favor of Dr. Rosenthal, so we were going to take this case to trial. Jim, your turn.
As the discovery process that I told you about winds down, we start thinking about pretrial issues, what motions might be filed, and I'll talk about that in just a moment. I mentioned the mediation in this case because Dr. Rosenthal did not want to consent, and rightfully so. We did go through the mediation, but there really were no settlement negotiations because we didn't want to and couldn't move forward on that. The case was felt to be defensible not only on standard of care. We had good solid testimony on that from our expert witness, but another pediatric ophthalmologist, but also on causation. And I think that the causation issue was very important in this case. We start thinking about things external to the case itself, that is the merits of the case, such as venue. Where has the suit been filed? What are the local laws that relate to a medical malpractice action? For example, what's the jury pool likely to be? And that's where we can help, or the lawyer in whatever jurisdiction you happen to be in. We get a notice, a computer notice every single day of every new case that's filed in Arizona, the allegations being made, the plaintiff's attorney, the defense attorney, and all of that, so we know what's being filed. And then we also get a trial summary of each and every case that's trialed, civil case that's tried, and criminal too for that matter if we wanted, although we don't do that. Every case that's tried, what the allegations are, who the experts were, and what the result is. And we, as a firm, get that, and so we know every single case that's tried in the state of Arizona and what the results are. So it's our job to provide input to the insurance company on local issues. Typically in Maricopa County, Arizona, fairly conservative jurisdiction, and we do have a great deal of success. There are other, and I supervise cases in other parts of the country, there are other jurisdictions where you can be very, very right on the medicine and very wrong in the courtroom. And all of these are the kinds of external matters that have to be considered and taken into consideration, not only by us, but by the client and the insurance company. So we analyze all of that. And typically we prepare what's called a pretrial report. And Paul mentioned that there might be a conference call, but we do a very comprehensive report, copied again to the client, saying, here, we're all pretty much done, here's everything, here's what we think, and here's why. One thing that when I was talking about the deposition process of Dr. Rosenthal, there's also a substantial amount of preparation that goes into preparing a client for trial. So the involvement of the practitioner is initial client meeting, maybe answering some written questions called interrogatories, a deposition, a settlement conference, and trial. That's typically it. You're copied on everything else, but most of the other stuff we do. Now, that's not to say that if you want to attend depositions, you can't. As a party, you're entitled to do that. But there are really only a few steps where your time and away from the practice is absolutely required. One of the things that if you're curious about it, I'm going to mention that the Defense Research Institute annual medical malpractice seminar was in San Francisco last week. One of the issues that was discussed is the reptile theory. And that's a whole other presentation, but I'll mention it, and I prepare all my witnesses on it. And for those of you who may be going through the process or may go through the process, if you start hearing questions about safety of the patient, be careful. Just go online and Google reptile theory and see what pops up. There is a very, very strong current with plaintiffs' attorneys who do a lot of medical malpractice work to shift the consideration of the jury away from standard of care, which is what is reasonable under the circumstances, to an issue of patient safety. For instance, in this case, and it wasn't a part of this case, but if Dr. Rosenthal had been asked in her deposition, doctor, would you agree that one of the important considerations for a physician is the safety of the patient? And you say yes. And patient safety should be a consideration at all times during the course of your care and treatment. Well, yes. And maybe there's a guideline or this or that. Everything I see anymore from hospitals and so on says patient safety this and patient safety that. And so you're taking down this line of patient safety. And one of the big issues in this case was the telephone call on Friday afternoon when the patient or the patient's wife testified that they wanted to come in, and the pitch was it was Friday afternoon and the practice didn't want to see them on a Friday afternoon. And so the question would then be, doctor, wouldn't you agree that in the interest of patient safety, it would have been better to bring this patient in on a Friday afternoon? Understand that juries understand safety. This concept of standard of care is not typically something they deal with. And so there is a major push on the part of plaintiffs' malpractice attorneys to push everything towards patient safety and away from standard of care. Just be cautious of that, and Google reptile theory. It's really kind of a fun thing to look up. Strengths of weakness of the case, we felt that it was very defensible on standard of care. I think also in my analysis of the case, one of the strong points for us was the causation defense. We had a very, very good retinal specialist who had testified before, and the issue, the plaintiff's expert was a pediatric ophthalmologist admitted that he would normally refer this case to someone else. He was testifying on both standard of care and causation. We brought in a retina specialist who said that this process was subclinical on the visit of the 26th. If it was even there at the time, that likely wasn't. And that on the 29th, on that Friday afternoon, basically what the whole case centered around, that although he couldn't say absolutely that it was subclinical at that time, to a reasonable degree of medical certainty, he felt that it was. They had really no answer for that because the plaintiff's expert acknowledged that he couldn't say to a reasonable degree of medical certainty, which, by the way, is the standard, that when the endophthalmitis would have been clinically detectable. So I think that that was a strong point in the suit. The weakness of the case, it centered around the Friday afternoon call, the claim that Dr. Rosenthal wanted to go pick up her kids instead of seeing this patient, and that kind of thing, all absolutely fabricated by the plaintiff's attorney, but nevertheless, that was their driving point. When a case goes to trial, there are a bunch of pretrial motions, and they were filed here. Our job is to go to the judge ahead of time before this case goes to the jury. These are jury trials. And say, Judge, we don't think that the plaintiff should be able to enter this evidence, that evidence, this evidence, that evidence for these reasons. Plaintiffs come in and do the same thing on the other side, saying we shouldn't be able to. We won some of the critical motions. We were able to knock out the loss of earnings claim. The claim was that this man was a warehouse man who drove a, what do you call it, a front loader or something, where they take stuff down from the stacks, and said that with his loss of peripheral vision on the right, that he couldn't do that anymore, and this lifetime of lost earning capacity. When I told you about gathering records, we had his employment records, which showed that he got into a couple of altercations with co-employees, and that his problems centered before the eye ever even occurred, centered around his work ethic and his interaction with patients. So we were able to knock out completely. They gave up. They voluntarily dismissed the loss of earnings claim because they didn't want us to present that information to the jury. One of the other motions, and I'm going to shorten it a little bit because of the time constraints, one of the other things that they wanted to do is have the plaintiff take his prosthetic eye out in front of the jury. We took the position that there were photographs and there was really no reason in the courtroom that the probative value, there's a rule called Rule 403, that the probative value of doing that in front of the jury was for nothing more than shock value, that it wouldn't add anything material to the case. That was denied, and so he was able to do that on the stand. The judge put some limitations, only one time, and some other limitations on it, but you know, obviously the jury was somewhat taken aback by that, and it was, but we lost that. We went to trial. Opening statement is really important. All the studies that relate to jury trials will tell you, the psychologists, the psychiatrists, the study this kind of stuff, jury consultants, most of the time jurors have made up their mind, at least partially, by the end of opening statement. That we tend to make judgments and then look through the trial for evidence to either support or refute their initial perception. Not that that can't be changed, it can. But think about it. You know, you walk down the street, you see someone approaching from the other way. You make a snap judgment, is this person a risk or not? So we tend, by appearances, to make initial judgments. So our job in opening statement is to boil the medicine down and present it's not a time for argument, it's what the evidence will show. To present that, however, in a very basic and very common sense way as to why what Dr. Rosenthal did met the standard of care and why the jury should listen for that evidence that supports the case. So we take a great deal of time to present a good opening statement. What happened during trial? We had a surprise. One of the strengths of the case certainly was Dr. Rosenthal, who did a wonderful job, and she has a tech who is in her 50s, just absolutely the nicest person, articulate, that you would ever want to meet, who had been prepped and deposed prior to the case, So we had her deposition. Plaintiffs had her deposition. She was prepped to testify at trial. And at no time prior to climbing onto the witness stand and getting under cross-examination by the plaintiff's attorney did she ever say that the wife on that Friday afternoon call wanted to come in. And she said that during the course of the trial, quite unexpectedly for everyone. So that gave us a little cause for concern. We didn't anticipate that. The Friday afternoon call was characterized as one where they were complaining of headache, and all of the information gathered would suggest that it was not an eye problem. In fact, the eye was okay. They denied that they gave that information, and that's why, and Dr. Rosenthal, based upon the information available, that it was not an eye problem, said if you have a problem, go to urgent care, which they didn't do. But in any event, that was a curveball that we didn't expect. There was a demand or offer to settle during the trial for $400,000. To her credit, Dr. Rosenthal refused to do that. We tried the case, and after about 3 hours of deliberation, the jury came back with a 6-2 defense verdict, and we won the case.
I sort of feel like clapping.
So hopefully I can tie some of the things together here that we've heard this afternoon, and again help minimize the stress of any of you who go through this claim, which statistically will be most of us, and maximize the ability to defend a case. So I just want to look at just a couple of points here of what was done. I think one of the things that Dr. Rosenthal did beautifully was her informed consent. You can't see the specifics of her informed consent form, but it's excellent. I'm sure you all know that we have one on the Omic website, and Dr. Rosenthal basically used a lot of that in hers. In addition to that, and very importantly, she wrote in the chart what you see here on the side about her discussion with the patient. How many of you all write in your chart something in addition to your consent form?
Good.
Okay. Yes, I see you, Dan. All right. So a great thing to do. Omic definitely recommends that this would be helpful if you have something in your own writing about what you discussed. How many of you actually tell the patient that they can lose their eye? Pretty good. I bet Dr. Rosenthal is pretty thankful that she did that. Okay, another thing, so first thing that she did extremely well was her informed consent. Second thing that she did particularly well was document. And the first post-op visit, that was on that Tuesday, she wrote down the patient was having headaches, used ibuprofen, and was much better soon after. Now, talking about hindsight, well, yeah, great. In hindsight, I can see that was a great thing that she wrote. But if one of my patients comes in on the first post-op visit and they're doing great and everything looks like it's going well, and they said, oh, by the way, I was having headaches and I took some ibuprofen and I was much better afterwards, I'm not 100% sure I would have actually written that down. So more documentation is better. Obviously, the critical one was that Friday where the technician wrote and discussed with Dr. Rosenthal that the eye, even though he had been having these headaches and the pain had become more severe, the eyes were looking better, they looked good, and the redness was improving. Obviously, that was a very key thing to have in the record. So again, don't forget to document your phone calls. I'm sure everybody does that extremely well. Dr. Rosenthal also was very alert to who was present at the exam. She told me just before this talk that she actually had not recorded who was present at the exam, but now does that. And I think that probably you can see from looking at this case and what happened with the wife, why that would be good. I personally find it pretty helpful for lots of things, phone calls later, well, I didn't get a call back, I called you, you didn't call me back, or, you didn't tell me this last time, and then you look back and it was the father that was there instead of the mother. So more documentation is better. There were a couple things that were not documented. The phone call on Monday, which was when the patient asked if he could take ibuprofen, and the post-op visit was moved one day earlier. I'm not sure how important that was to the case, but also the slit lamp exam was not documented. I wanted to go over with you, I asked Dr. Rosenthal, what did she learn from this case and what might she do differently now? And I just want to read to you exactly what she said. Had we not documented that phone call that Friday afternoon, I would have not had a leg to stand on. Since that time, I think I'm even more conscientious about that. I feel like the more detail, the better. And also to document that the patient or parent understands the plan and agrees after the phone call. Now, how many people in this room have been to Omic talks more than 3 times? Almost everybody. How many times do we sit up here and kind of pound in, you gotta document, document, over and over and over again? And this is why. We survey at Omic everybody who's been through a claim, whether it was settled or tried or whatever. We ask them, what would you do differently now? And by far and away, the vast majority of people say, I will document better and I will document more. So we don't come here to tell you guys this just because we like to hear ourselves talk. It's because that's what we see over and over and over again. And then as I was reviewing this case, I also thought, well, Dr. Rosenthal's technician is very good. She did a good job documenting that phone call, and I think my technician would have done the same thing. But are they the ones who always talk to these patients? I mean, sometimes maybe it's a Friday afternoon and my technician is already gone. What if the phone operator took that call? Then what might have happened? What if the phone operator on Friday afternoon didn't get that call to me or to my technician? And so you can see where maybe things can happen that would not be our preference. And so just always important to go back to your office staff and help them understand the importance of communication and educate them on the questions that they should be asking the patients and a protocol for where those calls should go. I'm sure most of you know that we have a telephone document on the Omic website about how your staff can handle calls. And finally, just to kind of go back to where we started at the beginning of this was a long, painful process. I mean, I cannot imagine for all these years having this thing over my head and worrying about it and knowing that it's there and what's going to happen. And it's told. Dr. Rosenthal seems to be incredibly well adjusted about it, but certainly it's an extraordinarily, as she said, brutal process for most of us as physicians. And so hopefully this afternoon, we've given you ways to minimize the stress and maximize your ability to defend a claim should you have one. So thank you very much for your attention, and we will be happy to answer any questions.
I would like to just ask one question, or ask Dr. Rosenthal to talk a little bit about what she was going through this 4-year process, because it's pretty interesting, sort of some of the personal issues that were going on in your life, including the children.
During this whole time period, I actually had 2 babies, so I had to sort of manage that and everything that went along with that. So there was a lot of, when I first, I had a different lawyer to start with, and when we started, he said there's a couple different ways to manage this. You can call me all you want, you can bug me as much as you want, or you can do your job and be a doctor and be a mom and everything else that you do, and I can be the lawyer. And I chose to go down that road and trust in my attorney and sort of step back. And as much as I thought about this every single day of those almost 4 years, I did my best to let Jim and Mike do their jobs, and I continue to do mine. And I think that's what kept me most sane during the process.
Great. So if there's any questions about this case, oh, please.
I just had a quick question. I was under the impression, I may be wrong, in New Jersey, if a physician has a case come up and the insurance company says that we think we should settle for this amount of money and the doctor doesn't agree, if he chooses to go a separate way, he's responsible for the judgment against him then, or is am I misunderstanding that? That if you disagree with your insurance company, that you're on the hook for the settlement if you lose?
It can vary by state or by insurance contract. And so some insurance contracts, there's something called what's called a hammer clause. So if we think we could settle a case for, say, $200,000, we got the demand from the plaintiff, and it was $200,000, and the insured says, no, I want to go to trial. So it could be in this clause where you would be responsible for any amount over $200,000. In Florida for a while, up until probably about 5 years ago, statutorily, by law, the doctor did not have the right to withhold consent. So the insurance company had to, if they felt it was reasonable and proper, settle the case, and the insured had nothing to do. We still worked when that law was in place with our Florida insureds and worked around that, but that was a law. So it can vary by state law. It can also vary by insurance contract.
Yes. Primarily, it's insurance contract,
Yeah.
I think, with regard to the hammer clause. I would say that if New Jersey has a statute or something similar to Florida, those are mostly the outliers. Typically, consent clauses in most jurisdictions are honored, and you're not forced to settle a case that you choose to try.
And Omic does not have a hammer clause. Over there, and then we'll go back to here. I can't hear the mic on there, sir. Mark?
Are you on back there?
Yeah, now we hear you.
Okay. Last year, a colleague mentioned he had a terrible experience going through a lawsuit, and that one of the key issue he mentioned was the use of pens. He says he uses various pens, picks them up and puts them down, and he said, they say, oh, you changed the record because we have proof, blah. Well, I have about 6 or 7 pens on my desk, and I use at least, I might have a scribe who writes some, and I write some, and some, it's all usually the same color, but man, could you comment on that?
Well, yeah, I've seen that argument made before, but I think that how we've addressed that in those situations when necessary, and for the most part, we can establish that the use of different pens isn't anything out of the ordinary, because you may see the patient, may take a history, do an examination, write the results of your examination with a different pen. So typically there are logical breaks about when that might occur. Also, sometimes the records are completed at the end of the day before they're actually signed. It's the signing of it that makes it something that you then have difficulty changing without dating and signing it. But what we've done in some cases where it really became an issue without identifying the patient in any way, showed that there were other charts in the office done exactly the same way. And that usually takes the wind out of the sails, and then it went no further.
Over here, sir, doctor.
Would you comment on how electronic medical records have altered the legal environment for us? Are they working to our advantage? Are they working to our disadvantage? And if so, how?
Once the electronic medical record system evolves down the road, it probably will be advantageous. We have handled multiple death cases arising out of electronic medical records, primarily hospital cases, medication errors, and to this day, there are EMR systems in, for instance, hospitals where the ED record doesn't talk to the rest of the hospital system, where practitioners' records don't, it's a process. Now, at some point, it will be okay, but the problem with EMRs, you have drop downs, you know, you'll say, I've seen just the most outrageous things. Patient ambulates well, and she died 4 hours before that. All of these drop downs and fill-ins and so on, and the elimination of the actual narrative. It is so important to have a narrative. And if you look at hospitals right now, for the most part, on the part of the nurses, they're trying to eliminate the narratives. I think that if you're going to, which you have to, use electronic medical records, you have to be really cautious about the drop downs, the macros, and all of that, and make sure that you put a good solid narrative in that explains what was actually going on. Because a group of clicks on this option or that option doesn't really necessarily give you that full picture.
We were talking about that question before the meeting here, and we were saying how what is the output, what is printed out on the patient's record is nothing of what the doctors and the technicians are seeing when they're doing the input, and how the defense attorney really almost has to sit down and see what this electronic medical record looks like to the doctor.
Well, and it's even worse than that, because we almost never, and I know that I'm using a very strong word, receive the entire chart from our own client when we request it, and we didn't in this case. In this case, we requested the record, and I say, you know, every note, every billing record, every this, every that. And later on, when it was too late to use it, we learned that there is something that's not a part necessarily of the patient chart, but it's the task communication between the techs and the doc and so on, and we didn't have that. And so it's very difficult for us to even gather up all of that. Typically, gaining records is assigned to some person in the office. They don't have a comprehensive understanding of how important this can be, and anytime you don't produce that complete record, every single screen, every single everything, then there's always the allegation down the road that you were hiding something.
Well, I can only wish then that you would talk to the hospital lawyers. This stuff is being forced on us.
I understand that.
And it leaves us at a legal liability, which I don't think is fair.
Another couple questions, and we'll...
Yeah, Rick Saunders, Charleston, South Carolina. I just didn't hear, but I had a particular question about this case. Was the organism ever identified? Was it cultured?
It was. Initial culture was negative and then came out and grew out staph.
Because if it was a gram negative, I don't think any of those eyes survived, so it would break, the case would break on causation. So.
As I said, we had very strong causation testimony.
Pardon?
We had very strong causation testimony.
Might want to mention this.
If anybody has not turned in their gold sheets to get your discount, you can give them to Bob Gold there or bring them up to the front.
Thank you very
all
much,
very
everybody.
much for coming.
Appreciate
Appreciate
it.
it.